To Lunch with Littman Krooks. My name is Joel Krooks, and I am an attorney here at Littman Krooks. Thank you for taking the time out of your day and joining me for this discussion. Today, I will be discussing whether you are too young to have an estate plan. This will be around a 20 to 30-minute discussion, and I will try to answer any questions in the chat at the end. First, I will discuss strategies that will help in the case an individual becomes incapacitated. And then I will discuss the importance of having a will at a young age, or no matter how old you are. So, are you too young to have an estate plan? The short answer to that question is no, you are not too young to have an estate plan. No matter how old you are, you never know when something bad will happen to you. You never know if you might slip and fall one day, or if you get in a horrible car accident. No one was anticipating COVID. Nobody knew. There are certain things in life that you cannot control. Something that you can control is having advanced directives in place that allow you to decide who will make healthcare decisions and financial decisions for you in case something does go wrong. Now, what are advanced directives? Advanced directives are legal documents that help provide guidance and appoint agents to assist you in the event that you become incapacitated. One advanced directive is a power of attorney. This will allow your agent to make financial decisions on your behalf while you are incapacitated. For example, say you need bills to be paid while you are incapacitated, or they need access to your bank accounts. This document will provide your agent access to your financial accounts and allow them to pay bills for you. An advanced directive that goes along with the power of attorney is a statutory gift rider. This document will allow your agent to make gifts to himself or herself above $500 in the case Medicaid planning is necessary. We highly recommend you have this document at Littman Krooks. Now, those are two documents that assist in financials. So dealing with your bank accounts or dealing with any brokerage accounts or paying bills. There are also healthcare advanced directives that can assist you and your doctors in the event that you become incapacitated. I'm going to discuss three different ones. First is the healthcare proxy. This will allow your agent to make healthcare decisions for you while you are incapacitated. So that one focuses on decision making, and it's important that you appoint an agent who knows about what your wishes are regarding your healthcare. The next document is a Hipaa. This will allow your agent to have access to your health information. So this document allows your doctors to speak with your agent and communicate with them about what is going on with your medical needs. The last healthcare advanced directive that we recommend is a living will. This is an instrument that states your preferences for a variety of possible treatments or procedures that a physician might need to perform. For instance, whether you want to be resuscitated or whether you want the physician to do whatever is in their power to keep you alive, even if you have a slim to none chance of survival. There are certain preferences that people have that they need to be stated on a legal document in order for their agent to understand. Having these advanced directives in place will allow your agents to act without having to start a messy guardianship proceeding. These guardianship proceedings can be expensive and very burdensome, especially when you just suffered a tragedy of becoming incapacitated. Advanced directives give you the option to choose your agent and let them know your wishes and not have the court or someone you don't want make decisions for you on your behalf. Anyone over the age of 18 should have advanced directives. Once an individual turns 18, they become a legal adult and their parents are no longer automatically involved in their health and financial decisions. This is where advanced directives become key in order to make sure that your parents or significant others are involved in your decisions. You want the person that you appoint to be involved. Oftentimes, your children, when they turn 18, they go away to colleges in different states. If something happens to the child, it could be very difficult for parents to speak with doctors or deal with financial situations while they're at school. It's especially important to have these advanced directives in place when your children go to colleges in different states. You will also want the advanced directive or the healthcare proxy of that state. So for example, I went to the University of Wisconsin, and it's very important that when I was at school, that I have the healthcare proxy of that state, so of the state of Wisconsin. This will allow doctors to be familiar with the healthcare proxy. The New York one would be valid, but it'd be better if you have both. The agent you select Another example of why you want advance directives is because you might have parents who are divorced, or you might have a parent that you trust more than the other. For example, say one of your parents is a doctor or another one is a banker. You might want your doctor parent to be your healthcare decision maker in the event that you become incapacitated. Or you might want your banking parent to be your sole financial decision maker in the case you became incapacitated. You also might have parents who are divorced and they constantly fight. And so you want your parents to know what role they will play in the case that you need them to make decisions for you. Now, the agent you select have to act as your fiduciary and act in your best interest. It is important that you select people you trust in order to not be taken advantage of. But there is very little downside to having advance directives in place at a young age. These documents are easily revoked and can always be changed. Once these advance directives are drafted, you want to keep them in a safe place and let your agent know where they are. This will give you peace of mind and allow your agent to be able to easily access the documents in the case of a sudden tragedy or a sudden event that causes your incapacity. So now that I've spoken about advance directives and how important they are to anyone, no matter your age, and especially once you turn 18, it's important to have advance directives in place. I will discuss the importance of having a will, no matter your age. A common myth among young adults is that they don't believe they have many assets and therefore have no need to plan. However, a will is not solely about your assets. For example, if you are a parent with young children, in a will, you have the ability to appoint a guardian of your child. In the awful event that both parents pass away, it is important for the will to appoint a guardian of the child and for you to know who that guardian will be. It will give you peace of mind, and it will be better. It's better that you make the decision on who is the guardian than for the court to. You want to let that guardian know that they will be the legal guardian of your children in the event that a tragedy happens and both parents pass away. In addition, in New York, if you are married with young kids and you pass away without a will, then you're therefore dying intestate, any individual assets in your individual name will be distributed based on the intestate statute. In New York, this is the first $50,000 plus 1/2 of your estate will go to your spouse, and the remaining balance will go to your children, no matter how old they are. They could be 1 or they could be 10. No matter what, they would be entitled to a share of the assets. So for example, say you have a house or a bank account in your individual that is individually owned by one spouse. If this spouse were to pass away without a will, their children would be entitled to a share of the house or the bank account. This can be a nightmare with the courts and be a very painful process, and therefore it's important to have a will in place in order for the assets to pass the way that you wish them to pass. It's likely that you want everything to go to your spouse because they likely need the money once you pass away. Also, people are getting married later and later in life these days, and people don't believe in marriage at all. A lot of people don't. And if you don't create a will, then your partner who you have or your significant other that you have will not be entitled to any of the money because they are not your spouse, and you do not direct in your will how your property is to be distributed. So if you have a loved one that you care about, but you just don't want to get married at this point, you should have a will in place so that they will be able to so assets will be able to be distributed to them upon your passing. It is especially important to have an estate plan if you have a child or a sibling with a disability. If you suddenly pass away intestate, that means without a will, then depending on your family tree and who survives, it's possible that your money goes to a child or a sibling with disabilities and messes up their benefits. It could put them above a certain income level or a certain resource level that will just have a negative consequence on the child or sibling with disabilities. There are certain planning techniques like supplemental needs trust that we can incorporate in a will that will allow this child to have their benefit, keep their benefits, and also be distributed assets upon your passing. So it's especially important that if you have a child or a sibling with disabilities, that you have a will in place in order to provide for them correctly and not mess up any benefits that they are receiving. Something very easy that everyone can do and everyone should do is make sure the beneficiary designations are updated for any financial institutions or accounts that allow it. So say you just switched jobs and you had to roll over your 401k. You need to make sure that that beneficiary designation is updated in order for your account to pass and avoid probate. You do not want to have a probate or administrative proceeding, and it will make it easy for your accounts to pass at your death if you have a beneficiary designation in place. We also recommend having a contingent beneficiary in case your primary beneficiary is unable to receive the assets at the time of your death. Now, these beneficiary designations can play an important role if you have an account in an individual's name. Instead of going through a messy probate proceeding that will be expensive and take time and be burdensome, the banks will simply allow you accounts to pass to your beneficiary that you designated. Another financial tool that you can use is have life insurance. So life insurance when you're younger is a lot cheaper because the chances that you pass away are a lot less likely. So the companies are willing to give you good deals on life insurance. Life insurance can create financial stability and security for your family in the event that you suddenly pass away. Now, you should talk to your financial advisor about whether life insurance is right for you and whether this is something that you should look into. But many people who are young, I would recommend have at least some form of life insurance if they have a family or if they want to provide for people when they pass away. Again, you never know when you might pass away or what event might happen. Obviously, COVID and the pandemic has shown that anything is really possible, and our world is completely upside down right now. And everything's changing at a moment's notice. So you want to have the right advance directives and estate planning in place in order to have your loved ones be able to be ready to go in the case that something happens. All of these documents make everything a little easier on your family when they are dealing with such a difficult situation. You do not want your family having to fight and have a tough time when something tragic just happened to you and you became incapacitated or you suddenly pass away. You want to have your family have guidance and know where and how you want everything to be distributed. Now, we at Littman Krooks are here to help you navigate through this process and draft the documents you will want/need in the event you become incapacitated or pass away at a young age. We have a program right now going that any individual under the age of 40, we will do a will and advance directives for them for $2,000. And then we will also, if you're married, we will do both spouses' will and advance directives for $3,000. If anyone has any questions, I'm happy to try to answer them at this point, but look in the chat. Don't see any. So if it's okay if your beneficiary lives in another state, it doesn't matter. I see it privately that I received this question. It's okay if a beneficiary lives in another state. They don't have to live in the state that you live. The banks will still communicate with them and work with them. Again, I cannot stress the importance. For the cost of the estate planning, it's for $2,000 for simple matters. So if you have a complicated matter where you have a sibling with special needs, that might vary in the price of the program. And I can't stress the importance of having a will. No matter how old you are, you never know when you're going to pass away. You never know how it's going to affect others around you. And it's also important to have advance directives in order for people to be able to deal with your incapacity. You don't know what's going to happen to you, when it's going to happen, how it's going to happen, and you can only control certain things in life. And becoming incapacitated is not necessarily something you can control. In addition, these documents can be revoked and changed whenever they need. So you can change your will and revoke it at any point. It's easy to do, and you can just call us and give us a call at any point. So I see a question here. Can a supplemental needs trust be created at the time the will is made but pros/cons to wait until the will is used to create a supplemental needs trust. So a supplemental needs trust can be created at the time the will is made. There are testamentary supplemental needs trust that we can put in your will. We can also do third-party supplemental needs trusts that are created during life. Pros and cons to wait until the will is used to create the S&T is that if you don't have any money that you want to give to them at the current moment, you can wait until the will, until you pass away, so that it can pass through a supplemental needs trust at your passing. There really aren't any pros and cons to funding it while you're alive or while you pass away. It's just about providing the needs for your child or sibling with a disability. Another question is, what if my spouse and I have differences in opinion on what we want to include in our wills? You can each have separate wills with different provisions in it, and it's basically the first spouse to die. Everything will likely pass to the surviving spouse, and then everything after that will be distributed based on the surviving spouse's will. But we can include provisions, and you can come to an agreement with your spouse on what you would like to do with your wills and come up with an estate plan. We're happy to help. Okay, I found that the power of attorney may not be accepted everywhere. Sometimes the institution wants their own document signed, which typically is found out after the planning process. Is there a way around this process and have a POA that is accepted by everyone? So unfortunately, all banks are different and they should accept the general statutory power of attorney, but they can be very difficult and usually do have their own power of attorney that they would like you to sign. That's why if we recommend that any accounts you have, so say you have an account with Chase, we recommend you get Chase's power of attorney, and we're happy to execute that document with you at the time of the signing. So if you have an account at Citibank, they might have a power of attorney that they want you to sign in addition to the statutory power of attorney of New York. So we recommend that you sign the bank's individual one and have a general power of attorney that is provided by the statute. So unfortunately, there is no actual way around it, but they should accept everything. So how often should the power of attorney be updated? Will Littman Krooks reach out to update power of attorney if laws change? So the power of attorney does not need to be updated unless you want to change who your agent is. Now there are new power of attorney laws that are coming out soon, and we will send out, if you belong to our newsletter and get our emails, we will send out blogs and post about the new changes, and then you can give us a call and we will let you know if you need to update your power of attorney. But typically, power of attorneys do not need to be updated often, as long as you want to keep the same agent. If you want to change agents, we can revoke the prior power of attorney, and then you can update it with the new one. If you had to do one document first, which should you prioritize? Well, I would prioritize first having a power of attorney and having a healthcare proxy in place. That would help you in the event that you become incapacitated. And then I would work on getting a will in place in order to make sure that your estate is taken care of in the event that you suddenly pass away. So the three documents that I would mainly focus on are the will, power of attorney, and healthcare proxy. For wills, aren't they typically contested prior to execution, or at least have to go through the courts first? So yes, if you die with assets in your individual name, they will have to go through probate. And probate is the process where you submit the will to the court with a petition, and the court will select an executor or administrator based on your will. So if you selected an executor in your will, they will allow them to become executor. And they're not contested unless someone contests the will. So if you have, if there's beneficiaries who don't agree that the will was valid, then it might be contested. But typically wills are oftentimes not contested. And if you update your beneficiary designations, or if your accounts are joint, then those accounts will not have to go through probate. So you will not have to deal with the courts. So any account that you have, like a 401k, a retirement account, a brokerage account, you will want to update those beneficiary designations in order to make it easier at the time of your passing. My wife and I own a co-op apartment in Manhattan, jointly with rights to survivorship. Our wills leave everything to each other, and upon both our deaths, to our only child. Is there anything we should do to have it in place to make sure that our daughters gets the co-op? Something that we recommend is that you might want to put the co-op apartment in a revocable trust if the co-op allows it. This will allow your rev trust to control the disposition of your of the co-op at the time of passing, and it will also say you want it to pass to your daughter or son at the time you're passing, or both your passings, then it will go based on the revocable trust and will not have to go through probate. But not every co-op unfortunately allows you to transfer your assets into a trust, so it depends on your co-op. So can you share a bit more about special needs trust? For example, what happens with the funds in the trust after an individual passed away? So regarding a special needs trust, this is a trust that provides benefits, supplements governmental benefits for someone with disabilities. So say someone is receiving Social Security, then they will also be able to receive the income from a supplemental needs trust as well to supplement their government benefits. Now, there are first-party and third-party supplemental needs trusts. So a first-party supplemental needs trust is a trust that, say that an individual had assets in their individual name. So if my brother was disabled and he had assets in an individual name and he was didn't have disabilities when he was younger, then all of a sudden had disabilities when he was older, but when he was younger, he had assets in his individual name, then those assets would want to be transferred to a first-party supplemental needs trust. And a third-party supplemental needs trust is if I gave my brother money, or if any third party, if he received money from any third party, then he would want to give them money. And then at the end, when someone passed away, if they're on Medicaid, then Medicaid would be entitled to a payback from anything in the special supplemental needs trust. Of only the first party trust, not third party. The third party will be able to be distributed based on how based on the trust agreement. I think that answers all of the questions in the chat, unless anyone has a last-minute question. And thank you again for joining me today as I discussed that you are not too young to have an estate plan, and that you should have your advance directives and your will completed as soon as possible, because you never know when something's going to happen. But thank you all for joining me, and I hope you guys have a great day and stay safe. Thank you.